NACDL is the association of the nation's criminal defense bar.
I'm not an expert in prosecution discovery. I'm far from it. And so I thought about it. I put some materials for you together, but I really thought that ultimately today I would talk about things that, from my experience, have been valuable, and hopefully you'll find things worth considering and perhaps somewhat inspirational. From my perspective, I really only one objective from me, at least, that I'm trying to get forward, and that's just kind of weaponizing the discovery process. We all know that prosecutors are cheating every day. If we don't, I would imagine everybody realizes that. If you don't, you should. And the question just is, can we take that cheating and use it to our advantage? The bottom line is we're in these cases and we know they're incredibly difficult. I don't call myself a death penalty lawyer, although I've been doing this for 27 years and I see so many public defenders here, because we don't do that. We take whatever case kind of comes our way. And I know I had my first one in 1998, but I've had a lot of other cases since then, from drug cases to just about everything you could think of. But I think the rules pretty much apply no matter what the case is. And there's really no question, obviously, in the capital context, that discovery is incredibly important. It's really the difference maker in cases. And unfortunately, it's not the difference maker in too many cases because we just don't get it. So we know this study came out looking at cases that said between 73 and 95, 16% of the capital cases overturned in state post-conviction proceedings were reversed because of Brady violations. And those numbers obviously incredibly underestimate the amount of misconduct that's taking place, because that's the product of fantastic habeas lawyers who uncover all these things, or somehow a court gets it right down the road. But the reality is, I think, I take this perspective, I don't know if you do, my belief is they're cheating in every case. And I guess that's been my experience for so long that I'm not going to probably be able to end this lifetime without believing that. And I may be wrong, but I'll never know, right? They've earned the right through much conduct in so many jurisdictions for so long that I think we always have to have that perspective. They're cheating us. One of the problems that you all know is we're stuck with this materiality standard. And I won't go into it too much. All of you are familiar with the standard and much of the debate that's gone on about that. But the standard, obviously, on appeal is reasonable probability that the result of the trial would have been different. The evidence is only material if there is a reasonable possibility that, had the evidence been disclosed to the defense, the result of the proceeding would have been different. Kind of core, understandable findings. But of course, this rigs the system for concealment, right? Because if you're a win-at-all-cost prosecutor, and I assume all of them are, that attitude is going to infect their analysis. That's how they're going to look at it. They're going to know that on appeal, what's going to happen? The conviction's going to remain unless their cheating is somehow uncovered, which is very difficult. And then a court says it was so significant that it would have changed the outcome. So the system is built for them to cheat. If they have that inclination, and unless they have a miracle office that I still haven't heard about, some magical office out there where they say when you walk back into the office, great job on that death penalty case, too bad you lost. I don't think it works that way anywhere. So the system is built to take advantage of a materiality system that favors cheating. And that's just the bottom line. There's just no way around it. So they're really told to cheat. And unfortunately, as we all know, courts just don't stand up enough. And so, everyone has seen this debate, and we fight this all the time about the use of the Brady materiality standard in pretrial decision-making. And of course, we are advocating constantly for why that can't be used. And I'll talk about that a little bit in a moment. And we have to fight. We have to just be incredibly aggressive kind of in our approach to what little they know to make these decisions that end up in our clients having evidence withheld. So, obviously, big questions that we have to be litigating. How would a DA know what's important to us? Our defenses are fluid. They're changing all the time. We have information in our possession that they don't know, that we're not disclosing because our disclosure responsibilities haven't triggered. So if they're sitting on the other side and taking their analysis about what would make a difference, not knowing what we know and what we plan, obviously the system doesn't function well. So how do they really rationally assess cases from a post-conviction posture? And that's why it shouldn't happen. And who knows, of course, what jurors will think is important. So I'm going to skip by some of this because I know there's a lot to talk about. I want to get through some of it. A few cases have talked about that standard, and there's still an incredible lack of clarity about what it requires, and we just have to kind of go in there and ask for the most broad-based discovery, and we have to be persistent about it. And I would just, before I get into some specific issues and some specific points, for us, and I did, as Jeff said, my career has kind of been spent on two issues, strangely, and it's been informants for about 5 years, and now I've been talking a lot about phone call issues, which I'm going to bring to your attention. Maybe some of you know what's going on in the country in terms of this issue and how important it is in terms of how prosecutors and law enforcement are listening to calls. But obviously, prosecutors have an ethical duty to disclose plea agreements, but one of the problems that we all see is these unspoken agreements, right? Everyone knows what's going to happen, but it's not laid out, and it's not laid out for a reason because they want the advantage of jurors believing that the person is without an ironclad agreement. And so we have to study the history. We've got to look at this. That is one of the things we did in the litigation that Jeff mentioned. We looked back at 30 years of cases in which there were unspoken agreements. And so I would encourage you to look for these patterns, because if you can look for these patterns in which obviously there's agreements in place, but they're not being revealed, that puts us in a stronger place in terms of getting discovery, in terms of pushing for these issues. So Giglio, it very clearly imposes a further legal obligation to disclose impeachment material and provide exculpatory evidence, including that relates to witness credibility. And this is, as you know, is going to always be relevant to snitch testimony and accessory testimony. So again, it's this kind of, without going into detail, because it's such a short period of time, it is these motions to compel discovery. It is being persistent about this. It's about taking these things up on appeal when it doesn't go our way. So how do you get your maximum value from discovery litigation? So the issue always is, there's multiple issues, right? We're seeking this discovery because we want to be incredibly prepared for guilt. We want to be ready on guilt and penalty phase issues. We want to create concerns. Our best work is when we don't have a death penalty trial, right? And so we want to make this process, which I'm going to talk a lot about, we want to make this process so painful for prosecutors that they feel they have no choice but to go in a different direction other than death. So that is a lot, from my perspective, what this discovery process is about. My first death penalty case was in 1998, and the case exploded in, of all places, Canada, and we were able to do what's called letters rogatory litigation. And that took us into issues we actually were able to have full-on hearings on discovery issues and to get to evidence that we wouldn't have gotten to, I would have thought, in a million years. And that was the difference in getting death dropped. So what is this litigation? It's whatever you can do to make a difference. And that means going as deep as you possibly can, and of course developing issues that can lead to reversal on appeal. So we got to have faith. Your prosecutor's office is absolutely withholding significant discovery in every serious case because they can't afford to lose. And it's all going to come down to what you and your team can do and the enormous energy you bring to your task. I want to talk for just a minute about the Orange County experience, the experience that we had that Jeff mentioned. I don't want to tell war stories, but to give a sense, and I know this is an incredibly experienced group, But it's also people with a range of experiences. And so basically what happened in that case was I had 2 death penalty cases at the time involving 10 deaths in total. 8 in one and 2 in the other. And it developed somehow into a case involving a single informant who appeared on both cases. And that would kind of unravel a system that had been used for 30 years in terms of the improper use of informants, always withheld. And it's been such a great reminder that if you could have a 30-year informant program that you never disclose, even though hundreds of people knew about it, prosecutors, law enforcement, not one person spoke up during all that time, that it's a reminder of what we're up against, of how much they will lock this information down in the quest to win. So we looked at hundreds of cases, and we ultimately filed thousands of pages of motions, a 505-page motion on one case, a 750-page motion on the other, laying out what we thought were years of misconduct. It ultimately has led to somewhere around 20 cases being overturned, reversed, or new trials. And that experience has said probably what you would think it would say, that the system is so horrendously corrupt. I mean, it's not that you don't know it. Again, I want to say that. But just the level of the corruption, the level of the concealment, and for me, it's energizing because I know even when you uncover these things, it will not stop. And I've been having constant reminders of that. So the judge kicks the day off the case and later dismisses the death penalty for the ongoing persistent concealment of evidence that took place. And an appellate court ruled that there was systemic misconduct in the use of jailhouse informants. So then 2 years after that, this is what we know. One of the things we always kind of learn in these experiences, they don't change. You know, you can have a brutal outcome for them. You can have an appellate victory that should have scared them half to death or all to death. And it still didn't make a difference. So one of the things I did in a non-capital case is 2 years later, I came back and I looked at thousands of cases with the help of great law clerks. And we looked at those cases to see if any of the people that were involved with the informant scandal, when they went from the jail to the streets and testified, whether a prosecutor ever revealed any evidence about their misconduct in the jail. Like I said, we just began with 001 on case numbers, and we looked for the names of hundreds of deputies that we knew were connected. We found 146 cases. Not one of them had evidence been turned over. For me, that's incredibly motivational and exciting, and I know that sounds weird. It says that we have to kind of stay on them forever. You can't let up, and you have to be persistent. So they were 0 for 146. We had asked for recusal. We said, look, you got to recuse them again because they're doing the exact same thing. You told them to stop doing this. You told them to stop letting their fidelity to the sheriff's department interfere with their discovery obligations. They refused. It's as clear as day. But of course, as you know, I call Orange County a place of luck-based litigation, but that's the same everywhere, right? And so I didn't have the luck to have a fantastic judge again. We usually get those once in a lifetime. You know, we can do great work. I always say this, we can do fantastic work, but most of it gets unrecognized. And we just keep doing it and doing it and doing it and doing it, hopefully until it breaks. It didn't break with this judge. And I know, in Orange County, a fellow came in and ran on a reform program. He said, I'm going to come in, I'm going to change it. And we knew he was a phony, but he ran on it. So 2 months ago, after all this, a letter was released from the defeated prosecutor days before he was leaving office. And he wrote a letter to the people he loved in the sheriff's department, letting them know that none of these people would be put on what we have called as a Brady list. They even blocked out the names. They didn't want us to see who they were. But what was more remarkable was, and this is without getting too far in the weeds, you would think, one of the things that we have to keep pushing on always is, when they say to us, we've done a Brady test, what in the world does it mean? Right? They'll go, and courts give them this incredible deference. We've done our Brady analysis. We've done it. And we say, well, what does that mean exactly? What have you done? What have you analyzed? And I don't know if maybe this isn't your experience, but my experience is courts will generally not push into that area and say, what is it? What did you do? And that's exactly what happened here. I said, we've got 146 cases, Judge. They haven't turned it over on one. Why aren't you asking them what they did? What did they analyze? Judge refused to do it. So we get this incredible letter, and the new prosecutor doesn't even realize it. He says essentially, no one's getting any discovery. And what discovery should have been, the process should have been, to look at thousands of pages of documents. The federal government ultimately began an investigation in Orange County, and I actually believe some really phenomenal people in the Department of Justice have been involved with it. We're in a strange administration, and we don't know what that's going to look like ultimately. But last week there were prosecutors being questioned in my office with a court reporter, and that's unusual, I think. So you take the moments that you can. But here is the question that they asked to make a determination about whether to turn over Brady. They sent an email to hundreds of deputies and said, hey, do you still have materials? When you were a deputy back then, do you still have materials? And they answered things like, yes, I don't think so. And their Brady analysis, their complete Brady analysis, was whether they thought they were truthful to that question, which is what this letter says. That's my explanation of it. So instead of looking at the thousands of pages of documents and analyzing them to make a call about whether people cheated, they said, that email looks truthful to me, and ended the inquiry, and we would have never known but for, again, dumb luck. And now I'm so energized. In fact, we're filing a discovery motion right now. My law clerks are in one of the courts to come back to this court to say, what are you going to do now? We've caught them. We caught them on the 146. We've came back with this letter. What are you going to do? Are you just going to keep saying this is good, this is acceptable? And so, again, it's just an example of we just have to be relentless with these guys. They're never giving in because they always want to walk back to their office with a win. They always want to be the winner. And this stuff to them really doesn't matter. It doesn't matter. So that was our reform prosecutor. Basically, capital discovery litigation in reality, as we know, is like every other litigation. There's just, arguably more at stake, although most of us who practice kind of go, it all feels like there's a lot at stake in a lot of cases. And I can't really distinguish. I know this is a capital seminar. I can't really distinguish between somebody who's looking at life and someone who's looking at the death penalty, particularly in a place like Orange County where we know the future may be the same. So we have to bring this energy, and I know people are here for the capital, but obviously when we damage them in our cases, in our jurisdictions, we damage them for everything. When we eviscerate their credibility, we get to kind of carry that forward into the capital litigation. So that kind of energy for discovery litigation, hopefully we're duplicating in all of our work, and I'm sure that we are. But I do think, my experience, and I'm not sure if it's yours, is if we make it ugly enough for them, most of them, in the end, if it's between them getting caught in the ugliness and a death penalty verdict, a lot of them will step away. If we make it messy enough for them, and that has actually, I would say that's been my personal career. My career has been discovery litigation. I feel like since I was a kid in the office, it's been discovery litigation and making it messy. I like trials, I really do. I'm not a great legal person. That's why when Jeff said do the law on it, I'll do it. But I'm probably like most of you. I'd rather be in a courtroom, and I'd rather be kind of litigating aggressively on all sorts of issues. And I think when we do this, and we really take them to the mat again and again to the point that they don't know what's coming, and they don't know whether they're going to be even sometimes in the news, which became very much a part of our litigation strategy in Orange County, making it painful, developing new bonds and new relationships with people we ordinarily don't. That next prosecutor doesn't want that story. And we were able to turn the tides in coverage. So everything should be in your arsenal. You should be thinking about all the things, whether you reach out to people you've never reached out to, and put them in a position where they really don't want to be caught up in the mess that you're creating. So I'm going to transition to a subject that I've learned a lot about over the last year, and I really like you to learn a lot about, because I think there's a very good reason that it may be impacting many of your cases. So, if people will use informants, what do they really want? What do they really want? They want insights into what we're thinking. This is all about Sixth Amendment, right? This is all what they're really trying to intrude into Yeah, they want to nail people on cases, but they really want insights into what we're thinking. And nothing is a better source of that, of course, than our communications with our clients in the jailhouse and from them into our offices in the calls. And I'm going to come back to this. And I know a lot of you are thinking, well, I never talk to my client on the phone. Maybe your team does. But at this moment in time, as I'll explain, it may be a very good idea if you talk to your client on the phone. I know that sounds odd. So, phone companies, and I'm going to say this, and I had a lot of kind of surprise when I spoke about this at a conference recently. Phone companies are recording calls. Everybody knows that. And prosecutors and law enforcement are listening to them. And I'll explain how we know that. And I'm sure everyone at least suspects that. I'm going to begin with a company called Global Tellink, and it's a company that dominates the field of inmate calling. So they're a huge, I think they're now close to $1 billion a year company making kind of absurd sums of money off poor people. And Securus is a distant second, but they're competitors fighting it out. They've actually, as I'll explain, have been hurt a little bit by some of the litigation we've done in Orange County. Both have unlawfully recorded phone calls. There's been a lot of litigation about this, but in the last year, it's been more intense in the county where I'm residing. They have admitted that there have been calls. They put them in the thousands. I think they're more likely in the millions of recorded calls, and I'll talk about that. GTEL, so they provide service for 800 counties in total. It's a lot of counties. We're not even getting to the federal and the state. They provide service to 79 of the 100 largest city, county facilities in the country. And they provide service to over 2,500 correctional facility customers. And they have over 2 million inmates using their services. And this is just one of the companies. There's other companies. In fact, as we've been litigating this, it's interesting. Companies now reach out to me to tell me what a good job we're doing on the litigation. Because, of course, they want us to muddy up GTEL so they can benefit, although they're all of the same ilk. So, in 2018, the ACLU reported that GTEL earned more than $500 million on inmate calls. I think the figure is much closer to $1 billion because it's grown quite a bit. GTEL charges our clients the rates depending on the contract, 15 minutes to call. 15-minute call can range from 15 cents to $4.80. So, if you don't know this, the phone companies engage in a revenue sharing program with counties and other state agencies and federal agencies, and it's based upon call volume. So counties, they all get kickbacks. They don't pay anything for this pretty impressive service that they get, which I'll talk about in a moment. And they get millions in kickbacks. Orange County in a single year makes, which is the 6th largest county in the country, they made around $3.5 million last year in kickbacks, just pure kickbacks. It's legal kickbacks because they're probably making, and they don't disclose any of their numbers. I'm guessing they probably make, if they're willing to give 3, they probably are making 20, right? At least 20 or something like that. So huge sums of money. And they have this system, and this is where it gets really important for all of you. And I know some of you probably know it, but I think it's worth going over. They all have kind of competing technologies, and they're all investigative tools. It's all about, they're selling counties on their investigative tools. Everything that will help their investigative team, whether it's the folks in the jail, law enforcement, and prosecutors, in getting access to your clients' calls. GTEL has a product called Data IQ. It allows investigators to correlate data from multiple sources, and you can access it you can access this information in real time. If you don't know this, law enforcement in your county, and the reason why I'm telling you this story, if it was just an Orange County story, there's no reason to bring this to you. It's all in your counties. Again, it would be amazing if it isn't in your county. Securus, who's its competitor, has similar products. So in all of your counties right now, at this very moment, there's law enforcement that are listening to calls in real time. They're sitting, they can get it off their phones, they can get it off their computers. It's all being tracked, it's being correlated. And so then the question becomes, as a first question, is what would possibly separate out the data that comes from calls to law firms, right? Nothing. So to the extent they're calling and talking to you or your paralegal or someone in the office, it's all being put in the same reservoir of information being shared with really no controls. We'll talk about what they say are their controls. Incredible system, if you don't realize this, that's now there, is that they can look at the whole set of calls over a large period of times and do word searches. So if they're not just listening to individual calls from inmates, they're actually putting out names into the system and getting back all the calls that are connected to it. So this is very high-tech, very efficient, very effective ways of getting to information related to your clients. So again, you can search by booking numbers, PIN numbers, and there's this data mining, incredible high-end data mining, and calls are accessed in real time. So we all know that eavesdropping is not permitted. That the Sixth Amendment does not allow them to do this. There's state statutes. There's federal holdings on it. So what happened here in Orange County was that we learned that there was a system in place that was there for many years, a platform. And all of your counties have these platforms. And these platforms exist, and they get these calls that come in and do all the things I just talked about. And they had a system called Laser. And the Laser system was in place for many years, and they had ways to upload phone numbers. So if you were a lawyer and you wanted your number protected, in theory, you would give them your number. Has anyone here, has anyone here knows that their number is on a protected list here? Is anybody aware of that? So kind of a smattering, you're talking about, it looks like maybe 10 or 15 out of 300 people. And, some of you may have your numbers on lists because you're in a public defender's office and it's there. But they had a do not record list and a private list. No one understands. We're still in a state after a year of litigation as to why there were two different lists. We still don't know it. Attorneys and numbers could get added to the lists, but across the country, it appears quite clear that it's not working anywhere. And one of the reasons we know this is, and I'll talk about it in a minute, I put out 300 public records requests about 6 weeks ago. And that's why it was even hard to stand up here right now, because there's so many responses coming in. And basically what I did was I put out requests for all types of information like this, and that information will all be available. And the reason we did it, I'll explain, was to kind of negate some arguments that Global Tel has made. But what we got back has been pretty incredible. It really shows that there have been no steps taken to protect lawyers' numbers throughout this country in any of the places where GTEL is. Nothing. If anything, with great awareness, they've let it happen. So are you on the list? If you're not on a list right now, your calls are all being recorded. And I assume you know that. But you're probably not thinking about it. And a lot of you are thinking what I've always thought. I'm not talking to my client about anything substantive. Right? My whole career, I've blocked those conversations, but the reality is they still happen. And I know they happen because we've gotten calls back in the last year, and people make mistakes. And those communications take place. Sometimes they'll take place with an investigator or a paralegal. But right now, if you're not on a list that's working, all of your calls are being recorded. And they're being listened to by law enforcement for reasons I'll talk about. Because most counties, I don't think Orange County is anomalous. Most counties have folks whose job it is to listen to and access calls before it even gets to local law enforcement. So it was discovered there was over 1,000 calls recorded in Orange County. And Global Tel came out and said this was a glitch. We had a glitch in the system. It was a technical error. And it's, okay, sounds like a one-time technical error. This is a Los Angeles Times article kind of describing it. The sheriff says, all unintentional, no problem. And the Global Tel released a letter that said that, basically, and that name becomes important, that fellow down below, Darren Wallace. And again, I'm sharing more detail because I'm hoping you're going to take this into your counties. And you'll think about at least trying to do some of this. Again, particularly in capital litigation, where you have the odds stacked against us. Why not enter into this process and make it painful for them? So 1 week later, The key person in this litigation, this was not my case, was connected to the housewives of Orange County, kind of figures in where we work. And the next week, and the Los Angeles Times didn't connect even that they had, the story had changed, even though the headline now says, contactor blames human error. So in 1 week, Global Tel went from saying it was a technical error to a human error. And the reason that happened is something I've only figured out in the last month or so. And that's because of a public records request to another county where we learned the same thing had happened 3 years earlier. So we weren't the first location, it turned out, which they had no intention to tell us, nor did they tell any of your counties. So if you're a county with Global Tel, nobody told anyone that in 2015 in Charlotte, Florida, the identical thing happened. Calls were recorded, and what Global Tel did, and we've been pressing them. I have 6 subpoenas pending right now. We're going to be litigating on the 20th. What they basically did was they got scared that it was going to interfere with their business. So instead of telling any counties we have this huge problem, attorney calls are being recorded, they decided instead just to stay quiet, hoping that no one would ever figure it out. And they didn't. For like 3 years, it didn't happen. The next county was ours, and again, it was sort of dumb luck. So what happens is the court in Orange County says, you've got to bring your executives in. We've been lucky sometimes in litigation here. You've got to bring your executives in and explain what happened. And what happened, the reason why that change was made from technical to human was because they realized the gig was up. That on the stand, someone very well might have to admit that it happened in another location. So here's the letter they were worried about. We did a public records request, and we got this letter out of Charlotte, Florida. And again, this is kind of talking about what we're supposed to do discovery-wise. It's subpoenas. It's public records requests. It's everything you can get to. It's anything you can dream up. It's just kind of being as imaginative as you can. Because these folks won't release any of it. I asked for this letter. There was an article that showed up, kind of an obscure article, and I said, what's this thing that happened in Charlotte? And GTEL fought us, and I was pretty slow, actually. I should have gone immediately to public records request. And in that public records request is sitting in it this letter. I wish I was a little more ready today, but that letter is almost identical to the letter that was written that I showed you a moment ago from Orange County. The language is identical. That's why I have it highlighted. If I was to go back, if I can go back just a second, maybe that wasn't wise. Yeah, so you can kind of see it. The letter summarizes our recent discussion with Global Tel. Goes on to say a lot of the same things. And at the bottom, though, you know those great aha moments. I looked at it and I go, but it's signed by somebody else. They changed the person who signed. And the reason they did it is because they knew this guy was about to take the stand. They were worried that he'd get connected. And he's the key player in the Orange County litigation. So he literally just went in and changed the signatory at the end, hoping we would never connect back to what happened in Florida. That's how evil they are. That's how bad they are. So now we're again with a court, and we'll try to figure out what should happen. So why should you care? Again, we've done these 300 public records requests to counties. They've all come back and said the same thing. You're in the exact same situation we are. We're a little ahead because we know more, but your calls are being recorded. They didn't fix the system for the last 3 years. So if you have a capital defendant today, think about it. Who are they most interested in law enforcement? They're interested in your capital defendants, and we found that here. The folks they're listening to the most, the numbers they're trying to get to are calls from capital defendants, calls from major homicide defendants. That's what they're doing. That's what they're listening to. Between 2012 and 2017 throughout the country, they upgraded these platforms, and that's where the system broke down, if you even trust that. I don't even trust that it's happening the way they say, but if you believe them, they upgraded the system and they began recording all these calls from inmates to their clients. So the GTEL narrative is that the calls didn't make it on this list. There's the short of it, 1,300 phone numbers on the do not record list in Orange County, And all of those were left off and open to recording. So GTEL has said we inadvertently recorded 1,079 calls. What's bizarre about that is if you have 1,300 lawyers, even if you don't get regular calls over 3.5 years, the chances that you're going to have 1,079 calls over that time period is nonsensical. And we've been arguing and talking about that, including the fact that there's a 5-week period in this phone list where there's not a single call from an inmate to the jail of the 1,300 people. So unbelievable stuff that we're kind of just pushing back on. 58 calls were accessed by law enforcement. Again, we don't accept those numbers, but that's what they say. Listened to, downloaded, copied, in some cases turned over to the prosecution. So, 3.5 years of phone calls, hundreds of calls. GTEL insists hundreds of thousands of calls. GTEL says no. One of their problems is that one of the call numbers that should not have any calls has calls in it. There's 7 calls to the main office of the Orange County Public Defender's Office. So we hired someone to take a look at this. We just hired a person from the University of California, Irvine, to look at the probability that there could be this tiny number of calls in an office this big that takes this amount of calls. And what they put it at was, this equates to approximately 4 chances in 10 to the 61st power, namely less than 1 chance in a trillion. And that was the better numbers for them. The other one would have been too many trillions to put down in paper, so I told them not to do it. GTEL's response is, we don't think your probability numbers are necessarily accurate. So, my counter to them is, okay, is it 1 in a million? Is it 1 in a trillion? So, that's all on the, that's all coming up. So the problem again is, it's not just the calls are sitting there recorded. It's not that they're just sitting there and being recorded. They're being recorded. They've set up this system so they can access them, so they can listen to them. And so they can be turned over to the prosecution. And sure enough, on this list, the question, of course, is connecting the bad phone company to the bad law enforcement agency. And on this list, there is a single call that's accessed by a GTEL employee. He was actually connected to our informant scandal. He's their inside GTEL guy. He listens to 1 call in 3.5 years per their records, 4 hours before the sheriff's department starts listening to calls. So we think we have pretty good circumstantial evidence that those things are connected. Of all the days over a 3.5 year period, he listened to a single call. And by the way, it was to the Orange County Public Defender's Office's IT department. So, it was a call from this guy, and we know it, the guy who works from GTEL, in the jail to our IT department. And why was he doing that? He was doing it to check to make sure that recorded calls could still be accessed. 4 hours later, they begin to access our calls. Your county probably has something like this. We happen to get this in my unrelated informant litigation, never thinking it could be valuable years down the road. The Special Handling GTEL Monitoring Log. And we have a lot of this. I can show you pages and pages. In your jail, you may come from a small location. I'm telling you, deputies are sitting monitoring calls and making notes about them and sharing them with the detectives, with the members of law enforcement in your county. That's what they're doing. That's why they have this. That's why they bargain over this. This is why the companies come to them and say, we have these phenomenal services. So you should expect that all the calls to your client have been listened to. You should take that perspective. So another lawyer who did some really nice work asked this question of GTEL. Have you notified any others, counties, that received the upgrade? And we think there's over 300 counties that received the upgrade. That this was the 3rd time this had happened. It didn't just happen in Orange County. It happened actually in 2 other Florida counties. And he said in 2018, it's in the process. So again, nothing's happened. And we now, having subpoenaed these records, not subpoena, I'm sorry, done these Public Records Act requests and have hundreds and hundreds of pages coming back can see none of that happened. There have been no communications. Nobody has been told about it because they're more worried about losing the business than anything. In fact, in response to one of these public records requests out of New York, and I think so far about 30 other locations, there's an email from April 9th. And what they're saying is our legal department has asked that we send out the message below as a result of some recent confusion of our customers. We're in April of 2019, years after calls have been recorded. Skip to the bottom. Please note that it is not a result of anything Berrien County did. It's merely an FYI to all of our customers in the wake of what other counties misunderstood. So we're now in the third GTEL version of what's gone wrong here. It was a technical error. It was a human error. By the way, a human whose name they won't give us. Some human is responsible for all of this, no longer works at GTEL, they won't give us the name. Third answer now, April 9th of 2019, there's someone in the bad county who did it. It's no longer even a GTEL employee. So why does this matter? Again, I know, this is a non-conventional presentation, perhaps in a death penalty presentation, but this is so important. This is such a unique opportunity for those of you who have a capital case. I view it as almost no downside to pursuing the issue of whether your client's calls are being recorded. And I know people are thinking, well, of course there's a downside. We'll talk about that in just a minute. But I want to talk to you about late-breaking news. If you're following the events in Leavenworth, Kansas, and the recording of phone calls, if you're not, you should be. It's important to note this isn't 1, 2, 3. I don't think it's 100 places. I think it's everywhere. But how does it extend into federal litigation? In the case of People versus Carter, and I think this ruling was just in the last week. Core Civic, which was previously referred to as Corrections Corporation of America, they operate the Leavenworth detention facility. And the ruling is that the federal government and specifically federal prosecutors failed to inform inmates or attorneys of how to protect confidential calls from being recorded. Even when steps were required by Core Civic to protect attorney-client confidentiality, steps were not taken and calls were recorded. This is, by the way, the recording company here is not GTEL, it's Securus. So now we have the two major companies being involved in this. And Securus has a host of cases where they've done it as well. So Core Civic recorded video from inside attorney visitation rooms. If you're not following this, the same thing has happened in Alameda, California. The Alameda Public Defender's Office identified that there were calls being recorded by video inside their visiting areas at the jail. Same thing here. They're doing all of it. They're thinking of every which way they can get to our communications. So the Kansas Federal Public Defender brought motion to determine what information to be recorded and whether it was used by the U.S. Attorney's Office. And so the court found that the U.S. Attorney's Office was aware of the recordings and, quote, the U.S. Attorney's Office and its agents routinely relied on recorded calls and reviewed the calls. I mean, they're a step behind us. We don't have that connection yet. But think about it. These folks, U.S. attorneys who obviously should know better, sitting there listening to the calls like it was nothing. And it gets worse. The court appointed a special master and investigated. And the special master found that the U.S. Attorney's Office repeatedly took actions to obstruct, including the following. Intentionally choosing to narrowly interpret the order, failing to preserve hard drives that they had represented were locked down, ignoring the litigation hold requests from the Federal Public Defender's Office and a preservation order from the court, delaying informing its office of the litigation hold for 4 months and failing to enforce that hold when it did finally implement it, and impeding with the ability of the special master to meet with key witnesses and obtain key requested documents. So essentially, they've now laid out kind of the framework for how to deal with these Sixth Amendment violations moving forward. And So related motions have been filed in over 100 cases. So this is a pretty incredibly egregious violation of the 6, and the numbers are expected to grow. The quote of the court, the fairness of the system is called into question by systemic prosecutorial misconduct of the type alleged here. So, this scandal, and the reason I wanted to share it today and kind of have it kind of overtake the rest of it is I just don't get a chance to talk to folks much about this. And I will tell you this, to my great disappointment, we reached out to 150 public defenders' offices and we said, we're pretty clear this is going on in your county. The evidence is overwhelming. The same process has taken place everywhere. There's no difference in the technology. It's happened. Everything we've used here in Orange County can be used in your jurisdiction because it's the exact same issues. And the response was minimal. And minimal is an overstatement. So I know we're all dealing with a lot of issues and a lot of things and a lot of ways to kind of tackle our cases, but listening to our clients' calls should be at the top of it. And I think it should be the top of it in capital litigation, again, because you're looking for a way to make it ugly. That's kind of what I'm preaching here. That's what I've kind of preached my whole career. Make it painful for them. You can make it painful for them on this issue. And again, I can talk about an informant scandal in Orange County, but each county has its issues. This is not like that. It's not county-centric. Everything that's happened here is happening there. So that's been argued. In fact, what's also been argued is that what GTEL does and one of these other companies do is they put on the call when it comes into the office that this is being recorded. And this is the argument. Our court so far has said no, that doesn't close the door on it. And it makes sense because just think about kind of an incoming call to a public defender's office. It will often be routed through a secretary, right? It's not going directly to you. It goes through that main office and goes onward. We're assuming, when we talk to lawyers in our office, we assume people were not recording. I know that was naive, but we thought because we were on the do not record list that they actually were observing it. And we didn't give it enough thought. We just didn't think about it. And we think we were always taking that additional step of being protective in terms of what we said. We listen to some of these calls and they're painful. We think we've said things we haven't. We think we've said less than we have. I'm not on those calls, but I'm sure I've made plenty of mistakes myself. But we can't let them get away with the point that you raised, which is a very good one, because what do they try to do? Record our calls and then step back and go, hey, you knew they were recorded. Well, then why did we have the list that said we were placed on a do not record list? So it shouldn't work in both directions. So again, the calls have been recorded. You ought to believe it. It's happened. If you're here today, you have defendants whose calls aren't just being recorded, they're being studied. That's the biggest problem, right? If we were just in a vacuum of recorded calls and they were going to someplace, but the reality is, and we looked at this in Charlotte, by the way, when Charlotte actually did the right thing. Their prosecutor came forward and said, we have this problem. They did an investigation, and what they found was every single one of the recorded calls was accessed and listened to. So we're living kind of a fairy tale land if we believe they've gone through all these steps to record. They've given them all the technology. I'm showing you things about how people are sitting and listening to the recording of calls, and it's not happening where you are. So, of course, on capital cases, we know there's going to be a call cover on calls, right? I'm sure you get it all the time. Your calls, either the investigator or the district attorney will ask for a cover on those calls. So how would the calls to the lawyer not be part of what's picked up? It will. Unless there's a system that's operational and working that will divide those calls, all of them are going to you. You think when you get calls back that do not include your calls or calls to your office, that's because there are no recorded calls that they've kept. They're just cleaning them up. They're smart enough to know not to give you the calls to your office, and that's what they do. But they're getting every one of them. Calls to your office or calls to cell phones, calls to all sorts of numbers. So, the reward risk in seeking calls. we've had this. About 15 years ago, we had an embarrassing set of calls that were turned over. And they had all sorts of discussions in a capital case. And everyone essentially forgot about it. In those calls, you might be worried about that if you flag it, then there'll kind of be an open look at whether you in fact did have calls regarding strategies. And maybe some of those things were discussed and you're in a worse position. Here's the reality. Kind of because of the position they now find themselves, they will never admit that they have the recordings. So you're kind of in a good place. They can't afford in this era to say they have the recordings, but you in fact can say they have to have the recordings. The case that I'm litigating right now is a case in which there is no recorded call. And I am saying, my client talked to me on a call, and it's not on the list, it should be on the list, and we have gotten a year of great litigation out of it. Great painful litigation for them with lots of revelations. So all you need to know is you had a call with your client. If you had a call with your client, you should go in there and march and begin litigating this. By the way, they know throughout the country about how bad this could be. One of the things we can see on the returns on the public records requests is Global Tel losing business. And they're losing business all in the last 18 months as this litigation has ramped up. We'll ask for records, and they're no longer the provider, even though they're listed on their website. So they're worried, and this is a great spot to be at for us who's in a capital case, who needs something to put us over the edge, who needs something to make it ugly. So that's a really interesting issue, because what we've been up against is that issue, that the sheriff's... so the question was the link between the sheriff's department... You're asking about the sheriff's department and the prosecution in terms of the calls and the link, because we're often up against this battle, which is that they're working in the jail, and prosecutors argue they're not part of our team. They're not our investigative agency. Where we've had success actually including through the informant litigation is the argument that they have dedicated people in the jail whose job it is not just to move inmates, which is the traditional role, move inmates, accumulate some information, but they have this investigative objective. We're still battling this. This is going to be part of this litigation coming up. But obviously, our objective is to show, and this was where kind of some of that subpoena type litigation can take place, is to show that the sheriff's department is a dedicated investigative agency that's working on all cases. So if you have that department, and what they do is they collect calls all day, they study them, they send them out to the investigative agencies, they send them out to the sheriff's department, send them out to the prosecution. It's a very hard argument to say they're not part of the prosecution team. And that's what we're trying to do. And I think, as you see, you look at that document up there, and they're sitting there logging the calls and sharing that information. That is some of our strongest argument, that they have to be a member of the prosecution team. Anything else?